42 petitions being spoken about, because
Where are those 8 affidavits?
they are on file here at in
Is
the.
there a reason why those 8 affidavits were not produced?
I do not know why it wasn't. It was in the file with it. In a folder.
Another problem with the 8 affidavits of circulator is that when these things are time and date stamped, and we had many discussions with Solicitor Hyde, Mr. Blosser, and this office about acceptance versus just, a stamping, acceptance as valid versus just receiving something. When these are date stamped, they are considered valid. They're valid until challenged. That is what it is.
And that's a problem that I've had from time immemorial.
The problem with the 8 affidavits of circulator is that the 8 affidavits of circulator are sitting there. To what do they attest? They should never have been date stamped as valid. There are no petitions that go along with them. They never should have been validated by a date stamp.
Now,
Furthermore, the 8 affidavits of circulator attest that, again, as Representative Mahoney was up at the courthouse, he did not have the petitions with him, as you were told, because they had already been accepted between 404 and 407. Furthermore, the 8 affidavits of circulator, which don't attest to anything in the way of petitions, do attest to something. And it attests to this, that his date range that he attested to on the affidavits, the June 1 to August 8, 2011, could not have been the date range. In other words, it's in refute of his court testimony, because he filed them on August 9th, 1 day later. Mr. Blosser, upon being asked on June 6th of this year what the 8 affidavits of circulator meant, said, well, those were for petitions that never arrived. They didn't make it by the deadline. Well, that means they were still circulating. And in fact, Representative Mahoney, in a subsequent HeraldStandard.com article of August 10, the day after the filing, said that he had upwards of 20 more still circulating. Now, whether or not that was an exaggeration, I don't know, but we know for certain that 8 petitions, because the numbers on the petitions, the signatory line numbers, suggest that there were 8 more petitions at least that weren't filed with the office. So there were 8 more petitions outstanding. They must have been circulating, as Mr. Blosser attested to us on June 6th. And therefore, that is in refute of his court testimony of August 22nd, 2011.
and
So
you
in
can,
other words, affidavit of circulators were filed here at the Election Bureau without any petitions being attached.
That's exactly correct, because the petitions were already filed. So they couldn't have been attached upon filing, because he comes back again at 425 over here, and hopefully
Then they were attached,
move this
dating a 1 through 8 August circulation.
yes, and who attached them?
Who attached
Then
them,
becomes, I mean, is the filer supposed to have them attached upon presenting the petitions, or is somebody else supposed to be able to attach
The
them?
Winterhalter notarized Mahoney affidavits of circulator.
Were filed without the affidavit, without the petitions being present at the time.
Were stamped as they were, and I have the 42, the 8 were stamped between 426 and 427, but from 425 to 427, the minutes of 425, 426, and 427, all of them. They were stamped like this. They were not attached because they are not in array. They are out of order. There are some 425s beyond the 426s, and some 426s beyond the 427s.
And when he brought the affidavits down, then they were attached to the petitions, correct?
This office subsequently aided
And does this...
Representative Mahoney in the attachment of those
And
affidavits of
does this-
circulation.
I do want to apologize to you. I do have physical therapy, and I will, Mr. Frasconi, if you would provide me with copies of everything that you
I will
have.
be more than happy to.
And I do apologize. I have to.
Now,
do this.
before you leave, is it possible to gain at least a vote to hold another meeting, to do
I'd like
something, to
talk
take
the
any
district-
action?
I want to talk to District Attorney Hennicks before I go any further.
Well, we have 2 issues, okay? We have issues that would involve, may or may not involve sending on to the district attorney, but we also have issues that have been clearly discussed here that deal with administrative functions. We don't need the district attorney to tell us whether or not we should hold a hearing for administrative functions.
I
So
would
why
agree with
not,
that.
why
Well,
not
the
set it?
administrative functions, again, I don't know, I'd like to.
Well, we just heard some of them. Did you accept, as a matter of practice, does the election bureau staff accept affidavits of circulators without having any petitions attached?
Normally, a petition normally has an affidavit already fixed to it.
I
on the
understand
backside.
that.
This is
Is
something.
it No, what I asked is,
I would-
have,
all right.
as
I
a
would-
matter
thanks.
of
Yeah, we'll
practice,
send that to you.
are you handed affidavit of circulators without any documents attached, and do you accept them?
No,
Well, you don't have any other circumstances you've had this come up,
No.
because it's always a pre-printed form in
Since-
the other circumstances.
If I may
Since you've
interject
been the
one
director-
second, he didn't on August 9, when they initially arrived without affidavits of circulator, he provided the affidavit. So obviously, he did not accept the petitions at 326 and 7 when they initially arrived. So no, the practice is you do not accept them without affidavits of circulator.
But the key thing also, as we have tried to explain, is that when the affidavits were returned, they were clearly altered. The Judge Warman's decision later included that the changes were made by Representative Mahoney. Well,
They were properly altered because they it couldn't have been filed the way it was pre-printed, because that had to do with the nomination petition and had specific language that Mahoney, we know now, couldn't have signed to because he didn't have any dates next to the names. So he had to alter it.
Then
It
they
was
would've-
supposed to be altered
I-
because it was a
I have that
pre-printed
here.
form.
well,
Then they
supposed
should have
to
been
supposed to
rejected
be
because he
altered.
couldn't meet the
No.
requirements.
And you
What-
can
what-
make that statement, but I don't think it's fair to say Mahoney altered them. It was a pre-printed form, it didn't really truly suit what he was trying to do. You can make the claim that this office should not have accepted it because of the range of dates. I think that is your correct.
Yes, and we can also say that this office should not have even provided a copy of another type of an affidavit to be used for a referendum petition. The burden should have been on
We would do
the
that-
filer.
They would do that for anybody. It was a blank nomination petition. You could come in there today and we would hand you one.
But it wasn't for a referendum petition, and
Because
that's
there
what
is no-
Representative Mahoney
there is
was
no form
attesting
for a
to.
referendum petition. That's what we talked about when we prepared this summer.
Well,
that
and
there
that-
are no
that's
Can I
why-
interject, though? He did not alter the words nomination paper, he left them there. He didn't alter that into referendum petitions. He did alter the oath for the date which is required to be set beside the name, which is a requirement of the law, and inserting this date range of his.
Right.
So that wasn't, in fact, it was an alteration because Judge Warman in his ruling spells out that he made a change.
Right, and
That
he-
change to me is an alteration.
He should have made further alterations, but it wouldn't have been improper to accept it. It should have said referendum petition and should have been able to say date next to the name, but since he had done the referendum petition wrong, it didn't
Well,
say that.
see, I would disagree that they were even correctable, because once you approach and there's no dates set opposite the names of
Then
anybody,
it should not be a
how can
conflict.
you return that? You should have said, it's rejected of State Representative Mahoney because you're not meeting the legal requirements, and these are irreparable, and the reason they're irreparable is
Because you
because
have no
you
idea
cannot,
how
you have
many-
no idea when these people signed, so you can't let him go back to his state legislative office and say, August 1, June 2, that would be...
Or
We wouldn't
even,
be here if that one step would have been taken by
Right.
internally or election
That's
office.
exactly right. I mean, these should have been rejected. As soon as these appeared, and there were defects on their face, and there were no, I'm sorry, but these do not meet the requirements. They must be returned to you for repair. And from what I can see, there are no dates. It's impossible for you to insert them now.
I think your
and so-
point is well made, but I don't think it needs to be an hour. Mr. Blosser understands your point, the commissioners, I think all understand your point.
Okay.
Well, there's no other commissioners here. Go on.
well, additionally, the date range is June 1 to August the 8th.
But no date range
How-
would be permitted under the statute. So it doesn't matter what the dates were, no date range would be permissible. Because it had to have the date next to the name, and so the affidavit should have just said the date that was next to the name.
Right.
Right, but officials don't know whether that date range is even applicable because there are no dates set on the petitions. It's not like
It could have
people,
been- it could
people
have
put
been
June
May-
1
in
to
other
August
words,
8,
It could have been May 25th through August.
or May 17.
Right.
That's right. So that puts that testimony of Tim Mahoney at variance if it's found that
Which
they were
would be,
circulated
in my
May
opinion,
17th.
outside of the purview of this election board to
Or
address,
your office.
okay? But you, to present that, then if we deem that it is questionable, then we move it on to the district attorney's office and let them do what they do best.
There is a question that was mentioned on May 17th circulation of the petitions on primary election day, and I heard reports of the same. And